organization, and also at times a little liability as well. So I thought looking at data from various dimensions. So I kind of looked at data from 4 dimensions. The first is data has become really enormous, and I'm sure each one of you would agree with me. Some facts and figures. I'm sure most of you know. 90% of the world data has been created in last 18 months. I can convincingly and very confidently tell you that the same data next 13 to 14 months will be created, and this as I said, this particular time is going to get a little lower, because I think this COVID has compulsively got every single enterprise, every single individual into digitization or digitalization. I'm sure a lot of organizations have already embraced digital digital transformation as a part of their ongoing journey. But I think some of the organizations who felt that there is some time, I think they are going to very, very quickly embrace this. On the other side, when we look at this enormous data, one of the other things which has happened, this enormous data in the last few years, is it's completely got liberated. Look at it typically in a traditional model, 4 walls in a room, perimeter, castle and moat model. The IT stakeholders, the CIO, CISOs, and the operations team had absolutely had complete control over the applications and data. And suddenly in the last few years, it has got completely liberated out of this 4 walls of a room. It has gone to cloud. It has gone on mobiles. It has gone on endpoints. It resides in the traditional data centers. It is on the IoTs. It is on Fitbits. It's all over the place. I think this is something which is worrying, because suddenly the IT stakeholders who had absolute control over this data, which is the most critical asset in today's parlance, have suddenly lost control. And I think they need to do a lot in terms of handling the data management right, so that the control comes back, which is getting more and more difficult. And with people getting liberated and users getting liberated because of COVID-19, everyone working from home, this situation has become even more difficult. Now let's look at the third dimension. As everyone has said, somebody calls data as the next oil, though I think with oil prices going down, it is not more any relevant anymore. But everything is being said about data, because data is being used in very, very effective manner. If you look at most of the organizations, most of the enterprises have looked at this big data within their enterprises and have converted it to smart, actionable data. Some of them to really build competitive advantage, some more to really serve their customers better, and many more who have actually embarked on the digital transformation journey have very, very effectively used this data to see to it how organizations can perform better and become more profitable. Let's look at the fourth dimension, which is not very heartening and a little worrying situation for us.
Sir, you have to unmute yourself.
Oh, sorry. You didn't hear me for how long?
For about 30 seconds, I guess.
Okay. So I was typically on the part that data is lethal if it goes into wrong hands. And I think this is a little worrying situation for each one of us, our enterprises, the governments, because this is getting very, very serious. Earlier, we used to think about that possibly there is a potential that one fine day we will get hacked, and we were using all preventive measures to really do that. But in the last few years, I think it has become typically the new norm. It's become a way of life. The organizations are getting hacked left, right, and center. And most of the breaches, if you look at it, more than 90% of the breaches, as per various analysts and DBIRs of Verizon and all of that, what we have seen is the root cause of 90% of the breaches is because of some gaps in technology, or predominantly because of ignorance of people. Now, which is very, 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 very critical for us. One of the breach which comes to my mind out of all the breaches that have happened, including the Cognizant and the Wipros and some of the other technology companies is the Sony breach, which happened shade 4 years back. 100 terabytes of data, more than 100 terabytes of data got leaked, and this Fortune 500 company was embarrassed. The leadership was embarrassed because the spreadsheets, which were more than hundreds and perhaps few thousands, were all over the place, being showcased by the hackers, which had very, very critical data, which is the social security. Just to further talk about it, it is not going to be until that we are going to be hacked or breached or potential for a hack. I think the adversaries are getting far more competent. We are playing basically a chase game. They also have an asymmetric advantage over us. So I think this is becoming very, very worrying for the entire fraternity as to how do we really safeguard this data. On one side, we are using it effectively. On one side, it is a very, very key critical asset of an enterprise, but on the other side, if it goes in wrong hands, can cause havoc for an organization. And for all wrong reasons, you can be enterprise could be in the media in bold because of wrong reasons. Now, with these four dimensions, I think it's very important for us to create a framework as to what we should do with this data. Data being the next or the new perimeter, data being the most critical asset of any organization. I think the first and foremost is it's about knowing your own data. And I cannot stress it anymore that it's very important for every single organization to know the humongous data which they have. And a lot of it is sensitive. It is about the protected health information for some companies. The sensitive data could be the payment card interface records in some other cases. For some organizations, it could be PII data for their customers. For some organizations, it is intellectual property. So I think it is very important to have a very, very scrupulous look at your data, identify the data which is very confidential, super sensitive, and know where this data is, what format does it exist, and who's the owner of the data. Now, after having done this step, I would say that discovery is just about a starting point, and discovery is not good enough. We need to discover this data and really start identifying and classifying this data. When I say classification of this data is that we need to put a tag on every single digital file or every single digital information which is data. And this tag should become a very integral part of this digital asset. When we move it, when we copy it, when we post it on the cloud, along with it. Secondly, we should use or we should induct some of the technologies like DLPs and encryption technologies and some of the technologies which are available on the cloud as services to see to it that we are aware of this classification. We can make use of this classification so that the users are empowered while they are handling this data, while they are copying this data, while they are moving this data, so that the data is not used, misused, or abused unknowingly. I think the other two critical part of the data classification is one is that the classification has to be persistent. It is not a one-time or a two-time activity. The data keeps getting added. The sensitive data keeps getting added. We have we have followed a culture that we don't ever delete our data. I personally feel that it's been some time that I have really looked at my data and groomed it well and all of that. And I'm sure most of us, because of so much of work, day's job and all that, perhaps I think this is something which we have left for the next day and it never happens. The other important thing about data classification is that there has to be a fair bit of automation that has to be brought in. We can't leave it to people to really use their best judgment or assumption and start classifying the data. And the their productivity will tremendously get hampered. And secondly, I think a lot of times the judgment and assumptions could be wrong because every single person does not know the complete business risk that data potentially carries. So good amount of automation and empowerment to the users is a right way to go. After we've done this, classification, and classification is not done for the sake of just doing classification. It is very important that we make this classification with the policies, the business policies and guidelines of the organization, which is enforceable. So what I mean when I say the enforceable policies is that after doing the classification, when we induct some of these technologies and use these technologies where organizations have already invested, a policy would be typically like a top secret data cannot be emailed. Sensitive data of specific nature can only be mailed to specific set of people or a work group internally within the organization, or a public data could be emailed to outside or the external world. So after doing this policy enforcement, which is a very key part, finally it has to be in line with the business risk and our capability as an enterprise to take that risk. The next step is typically the right access to the right user at the right time. Now, I think I can't lay any more stress on this because this is fundamental to everything which we talk about from a data perspective today. It has become about the user security, the human security. We keep hearing about zero trust. Give a specific user the right kind of authorization to right data. He or she should not have access to wrong data, because then it will potentially mean that we as an organization are at risk. But the fundamental to the success of giving this authorization and creating the zero trust, the fundamental is that we do the discovery and classification right. If we don't get this discovery and classification right, and we tag the digital assets wrongly, I can tell you all the investment made on the top line technologies which will help us enforce some of these policies, give the right authorized access to the right users, will all fall apart. Next, which is perhaps the most critical part, and I did say that you look at any report, majority of the breaches which have happened over the years, if you really look at the entire cyber kill chain, if you look at the root cause, it will start with people. 90% of the cases, it will start with people. So I think it is very important that we bring in a lot of awareness to the people within the organization so that they feel empowered and they fundamentally understand the difference between a sensitive data and a normal data and a public data. For example, somebody is really creating typically a spreadsheet, and in that spreadsheet we have some other IDs, right? So he should know that this particular data needs to be treated a little differently from a typical traditional data where which is a very standard data. Now, I think unless and until we bring this awareness to the people within the organization, I can tell you the first line of defense is as weak as ever. Lastly, I think it is important to know the legal and the regulatory perspective and our alignment. We should know that when we align with some of these new norms, we have heard about GDPRs, the Indian Personal Data Protection Bill is knocking the doors to become a law. There are a lot of things happening in terms of data sovereignty, data localization. We should also understand the liabilities which could arise for organizations out of this. So this is one subject where I will not make even one more statement because we have an expert of global eminence. I think a cyber lawyer whom I personally and the entire industry respects, who's been driving initiatives on behalf of the Indian government, behalf of the legal fraternity, not only from an India perspective, but globally, has been a speaker in the World Economic Forum for last 2 to 3 years. So with this, I would hand it over to Pavan to really take it forward.
Thanks, Harsh, for the wonderful starting that you made in terms of the landscape. Hi, friends. I think I want to just sensitize you about certain things that you may already know, but just there's a need for revisiting this slightly differently given the advent of this pandemic called COVID-19. Next slide. Next slide, please. Let's begin with this. Can we just go back, please? The previous slide. I want to start with the Cognizant case. Last week, this particular company has been hit by the Maze ransomware. Its data locked. It's already begun notifying its customers, and there's already talk of a huge economic loss or a revenue loss, all because data has been under attack. If the data was appropriately well backed up, potentially that could be mitigating circumstances, but nonetheless, There's no denying the fact that this is a reported case. I've been dealing with number of clients and their unreported cases, which have not yet come up in the public domain, but which increasingly is telling us that we need to be focusing on data. Next slide. Well, when I look at all around, I find that data security breaches are happening left, right, and center. It just is that as an Indian society, we are very, very secretive. We do not really want to report, despite the computer emergency response team mandating that we must report a breach of data or a breach of cybersecurity. So these are some of the instances that are already in the public domain, where humongous volumes of Indian information and data are up for sale on the darknet and in a variety of other cases. Next slide. Next slide, please. So in this ecosystem, one is beginning to start realizing that in India, AI has begun to start playing its role in terms of data, its processing, and maybe some portion of dealing with also the protection and preservation of data. As we go forward and as there's more digitalization happening, AI and data are going to be important paradigms that will be attracting your attention as corporate stakeholders as you go forward. Next slide, please. Well, when I want to talk of the Indian data protection law, let's get our fundamentals clear. There's no one data protection law in place in our country. We also don't have a data privacy law, though the right to privacy is now part of our fundamental rights. So the only thing that we currently have is the Personal Data Protection Bill 2019, which the Parliament in December had sent it to the Joint Parliamentary Committee. And it's still examining it when COVID actually struck India. So that's the current position as far as the current legal scenario on data protection is concerned. Next slide. Consequently, till such time as the new law does not get passed in the country, we have to be very clear that the only law that's going to apply to us is the Indian Information Technology Act 2000, being the Indian cyber law, and rules and regulations made thereunder. Why? Because it's India's mother legislation to deal with 7 raw materials that you use on a day-to-day basis, whether it's use of computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form. So this particular law also deals with some elements of protecting data and information in the e-format. Next slide, please. Consequently, you must be now crystal clear that all your actions and activities that you're doing as corporates, whether during COVID-19 or beyond, will all be covered under the Indian cyber law, being the Information Technology Act. So everybody is working from home. All aspects of work from home, the electronic data, and the related nuances are already covered under the IT Act. And you have to be mindful of this particular fact as we go forward. Next slide. Why is this law important? Number one, it recognizes legally electronic records as legal. Number two, it recognizes electronic contracts as legal. So your WhatsApp message, your Facebook message, your tweet, your Insta post are all now legal evidence, which can be used for or against a particular party in legal proceedings. So much so on 15th of March 2020, the Supreme Court in a landmark order has said that all judicial proceedings in India done by video conferencing shall be legal and shall not be called in question in any manner whatsoever. The ripple effect of this judgment is that all video conferencing done by corporates on their work from home platforms during COVID-19 have equally legal sanction, legal validity. They can be used as legal evidence. Next slide, please. Actually, the law basically talks about 2 kinds of things. One is normal data, one is sensitive personal data. you'll have to be very careful because different levels of data means you will have to now adopt different approaches on how to deal, handle, or process with data. For example, you actually, if you're given access to sensitive personal data, and sensitive personal data includes medical records, financial records, health records, confidential trade secrets, banking details. If you are dealing, handling, or processing with the same, and if you are negligent in adopting reasonable security practices and procedures, and as a result of your negligence, somebody suffers some damage, both you as a company and your employee can actually, working from home, be sued for unlimited damages by way of compensation per contravention. It's not one blanket amount, one contravention, unlimited damages. Second contravention, second action for unlimited damages. Further, if you are not properly dealing, handling, or processing sensitive personal data, and you disclose it to other people who are not authorized to access the same, then you also commit an offense under the IT Act, punishable with 3 years imprisonment and fine. Next slide, please. No wonder the Indian IT Act has given birth to various rules and regulations that have been made thereunder. One of the most significant rules is the Information Technology, Reasonable Security Practices and Procedures, and the Sensitive Personal Data or Information Rules 2011. These are governing all your activities that you're doing using sensitive personal data, and these compliances have to be done by you. You can say, look, I don't want to do compliances. I don't have the time, nor the bandwidth, and I will engage in the Indian classical Jugaad school of management. You could do that, but just keep in mind that if you do that, number one, my practical experience of more than 2.5 decades in the legal format system tells me it's very, very difficult to do Jugaad. And if you start creating false electronic records, that's a specific offense punishable with 7 years imprisonment and fine under Section 468 of Indian Penal Code as it deals with electronic forgery. So rather than doing Jugaad, it's better to be on the right side of law and do your compliances. Next slide, please. You don't want to do compliances? Please don't do that. What is your downside? Nothing. Just two kinds of downsides. Number one, you can be exposed to two kinds of damages. One is for certain limited categories, which is for normal data, corporate data, something which is not sensitive personal data. You can be sued for damages by way of compensation up to 5 crore rupees per contravention. In case if it's sensitive personal data, then its 5 crore limit has been waived off. It's unlimited damages by way of compensation that you can be sued under special courts under the IT Act. And they are mandated to do summary trial and finish up the matters in 6 months. Number two, you don't do any of these compliances, you run the risk of potentially facing criminal prosecution and liability. And you could be prosecuted for offenses which could range from 3 years imprisonment to lifetime imprisonment, and fine which could range from 1 lakh rupees to 10 lakh rupees. This is all thanks to Chapter 11 of the Indian Information Technology Act 2000. Next slide, please. Please realize that in this world, it's a different world altogether. Already a new cyber world order is coming up. So if you previously thought that you were not covered under the IT Act, think again. Today, when as a company, you're allowing your employees to work from home, you become an intermediary because you're providing a network service. On the network, you're allowing your particular employee to come and work for you, access your systems. So you become an intermediary. Once you become an intermediary, there are further other set of compliances that the Indian law mandates you must do. And what are these compliances? Let's have a look as we go further. Next slide, please. Before we realize why do we need to be bothered about intermediaries, let's read this definition. And I want to ask, well, there are 110 people, participants on this call. Ask yourselves, read this definition and tell me whether your company falls within the same or not, because it's one of the widely and most broadly drafted legal definitions of intermediaries, which has been defined with respect to any particular electronic record to mean any person who on behalf of another person receives, stores, or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online marketplaces, online auction sites, and cyber cafes. I invite your attention to the concept of network service provider. The moment you are allowing work from home, ladies and gentlemen, your company is a network service provider and you are already covered as an intermediary under the IT law. Next slide, please. Okay, once you're an intermediary, what are you supposed to be doing? The law says you are now required to do due diligence under the terms of the amended IT Act and rules and regulations thereunder. Now, this due diligence must be documented due diligence. I can't verbally say I'm complying. So remember, we're all seeing Mahabharata on television these days. In the Gita discourse, Lord Krishna gives you one central message. The message is, come to my Sharana and I will protect you. The Indian IT law has a similar message. You come inside my ambit, comply with these parameters, and I will grant you a statutory exemption from liability, which means I will guarantee you that you cannot be made to pay 1 rupee damages by way of compensation. You cannot be sent to jail. But that's only going to happen if you do your documented due diligence and your compliance is under the IT law. Next slide, please. Next slide. Further, under the IT Act, various of these rules have been put up. All of these impact data and information in the electronic form. Please have a look at these. Most of these are in a nutshell known as the Information Technology Rules 2011, but of particular relevance is the Reasonable Security Practices Rules and the Intermediary Guidelines Rules that are directly applicable to you for protecting data and information in the electronic form. Next slide, please. Harsh mentioned about you dealing with the Aadhaar information. Today, if you are as a corporate dealing with Aadhaar related information, you already have the Aadhaar Act. You also have the Aadhaar Amendment Act 2019, which has come into effect from July 2019. So please ensure that when you're dealing with Aadhaar related information or data, please comply with these two respective legislations as well. Next slide, please. Well, we've all heard about the GDPR or the General Data Protection Regulation, but that's primarily a European Union initiative. But think again, it impacts you in India as a company. If you're dealing, handling, or processing information pertaining to a European citizen, then whether you are in Europe or not, you still get exposed to the GDPR. And if you don't really comply, it could be a Damocles sword that could be hanging on your head, because you could actually be fined 4% of your gross annual global turnover in case if you're found to be in violation. So that's a huge risk for any corporates, even companies working in India. Next slide, please. Well, we had the Personal Data Protection Bill 2018 that got morphed into Personal Data Protection Bill 2019. That's now before the Joint Parliamentary Committee. It actually is seeking a distinction between both personal information and sensitive personal data. It's coming up with the concept of data principal and a data fiduciary. It is giving various rights, duties, and obligations for data principles per se. Again, it's not yet been passed. These are just some highlights of what currently exists. It's very much possible that the Joint Parliamentary Committee could be giving some major suggestions, which may then be incorporated by the government. And we'll have to wait and watch the final manifestation and avatar of the Personal Data Protection Bill as it comes forward. Next slide, please. But when I look at the current slides and the current bill, I find there are certain responsibilities and obligations put upon fiduciaries. Certain kind of exemptions have been granted for certain kinds of data processing, such as processing in the interest of national security, for legal proceedings, or for journalistic purposes. It also requires that a serving copy of personal data be stored within the territorial boundary of the country. And they say critical personal data has to be stored within the country. They have not yet defined what's critical personal data, but the way they have defined sensitive personal data, it pretty much covers a majority chunk of the landscape. So we will have to wait and watch as to what kinds of data is going to be defined. And of course, they are coming up with a new data protection authority, which will be set up to regulate the data protection ecosystem in the country as a whole. Next slide, please. Further, it's the data localization that you'll have to be slightly careful of. They are saying, look, all data in India within the territorial boundaries, there's been some lobbying, so they'll say, okay, the latest version is saying, okay, we are not necessarily averse to you having data outside. Please give us a serving copy in the country, and that's good enough. I'm not so sure in which side of the road will the camel actually sit by the time the final manifestation or the draft of the bill comes up. But the problem is, when I look at the definition of data under this personal data protection bill, I find that this is far more restrictive than the definition of data that's given under the IT Act. And further, the current definition of data is not likely to cover huge chunks of data that would be coming up with the advent of new technologies like artificial intelligence, Internet of Things, and blockchains. Next slide, please. Already I find that under the current draft PDP bill, there's a conflict between that bill under the IT Act. Please understand, the Indian IT Act or the Information Technology Act is a mother legislation. It's an umbrella legislation. One of the three most significant legislations in human history in India after we took our independence. Why? Anything to do with electronic format gets covered. So this personal data protection bill is going to be a subset of this broad umbrella that the IT Act is going to come up with. Next slide, please. So the problem, there are a lot of problems in the current PDP bill. It's talking about data processing, and it forgets to talk about data retention, data preservation, or the impact of the same on data protection. Also, it has no applicability on non-personal data. So for all non-personal data, that data is going to be deemed as an orphan data. So not particular specific protections have been yet stipulated under the PDP bill in this regard. Next slide, please. The danger signal is that all the offenses that have been defined under the PDP bill will be non-bailable, whether they'll be dealing with personal data or sensitive personal data. Further, we are not yet clear in what manner this data localization provision is finally going to take shape because of various forces and counter forces in terms of lobbying that's currently happening in terms of data being physically located on the servers in India. Next slide, please. See, at Pavan Duggal Associates, it's a new day for us every day and a new day of learning because we are assisting companies. During the COVID-19 time, we have been assisting a number of companies who have suddenly realized that they don't have done their compliances. So we're helping them do their compliances, both for data, for sensitive personal data, and also the compliances as intermediaries under the IT Act. Next slide, please. In fact, this COVID-19 has been a great learning experience. This is what some of the other people tell about us and our work. But I can tell you, look, COVID-19 has taught us there'll be far more new legal challenges. The world is changing completely, and we will have to constantly keep on updating our skill sets and our approaches and methodologies with each passing day. Next slide, please. Well, all I'll have to finally say in the conclusion is, please realize, till such time as the new law on data protection does not come up, cyber law is your guiding light in this choppy waters of COVID-19. Please ensure, get your due diligence compliances done, your data compliances done, because they are of crucial necessity. I always talk of the IT Act giving you a Suraksha Kavach. And in these choppy waters, this IT Act is not only giving you a Suraksha Kavach from potential legal exposure, but is also giving you a lifeguard so that you don't get drowned in these choppy waters. Because one thing is very clear, by the time COVID-19 comes to an end, we are going to see a huge wave of litigation, of legal exposures, legal actions, because companies would not have been able to fulfill their contractual obligations. There are going to be so many breaches. So we are going to be finding that almost everybody, every corporate is going to be facing themselves with potential legal exposure. My two words of request to you all would be, try to anticipate and visualize this legal exposure. Try as far as possible to do your compliances now, even if you have not done it earlier. Why? Because I want all of you to get under that Suraksha Kavach that the Indian law is giving to you. And once you are able to come under that particular umbrella, then even if you get hit by litigation, no problem. But you could still potentially argue that you are on the right side of the law. And because of this statutory exemption from liability, which has been upheld by the Supreme Court, you are not entitled to either pay 1 rupee damages, or neither are you or your top management entitled to be sent to jail. So just due diligence, compliance, and due caution will have to be your mantra as you go forward. Thank you all, ladies and gentlemen. Next slide, please. That brings me to the end of this particular presentation. We'll be happy to have any specific questions, but now over to Harsh after this legal scenario presentation. Thanks.
Okay, thanks a lot, Pavan, for that wonderful and very, very informative talk. And hey, Mahesh, over to you.
Thanks, Harsh. Hello, everybody. Good afternoon. Wow, Pavan, I think there were some great insights provided, and I learned a lot, especially implications that organizations would be going through if they don't comply. And you emphasized how critical it is for organizations to come under that umbrella, or IT Act ambit. So thank you so much for all those insights. Nagesh, if you just can share my slides, please.
Yes, just 1 second, just 1 second.
So while Nagesh is doing that, just a quick introduction. I'm Maheshwaran, and I manage Titus operations for South Asia. And really excited to do this session with you. And like Harsh mentioned earlier, my part of the session is going to focus on what should organizations be doing in orchestrating data security and how effectively they can do that through establishing identity to information. So that's going to be the focus for the session. Next slide, please, Nagesh. I think this was discussed in detail by both Harsh and Pavan. So data has become the new perimeter. We all are accessing critical applications and information from anywhere and from any device. And we are also seeing a surge in threats targeting data. I mean, there was a recent article from CERT India which said that they are seeing an increase in attacks on home computers, because I think hackers know that users are working on a less secure environment now, and mostly from their personal devices sometimes, and their home broadband routers are not essentially secure like the way it used to be when they're working within the organization. So a lot of attacks are targeting workstations. So hackers want to steal credentials. Hackers want to steal critical data by compromising endpoints. Next slide, please, Ash. Sorry, Nagesh. Next slide, please. Nagesh, can you hear me? Yeah. And I don't want to emphasize this. I think Pavan summarized it really well. So this is the global privacy map. Every regulator is mandating organizations to protect personal information. And we have just heard some great thoughts from Pavan again on what is the Indian government recommending organizations to protect critical data. So it's all about data. Organizations need to have visibility to critical information, visibility to regulatory information, and it's extremely important for organizations to come up with effective protection around critical information. Next slide, please, Nagesh. So data protection is not new for organizations. I think organizations have been investing significantly around people, process, and technology controls to ensure that they protect information. But as a consultant, when we engage with organizations and understand what are the challenges they're going through, despite making these investments, one, of course, they're saying that the volume of unstructured data is increasing significantly. They have to deal with petabytes of it. And they do not know what that information is. They don't have enough context about that information, because it's business users who create information, receive information, and share information. And it's not going to be possible for IT or security to understand, IT or security organizations to understand what value these informations are going to bring for different business functions. And these information are not staying within the organization boundaries. They're also stored in platforms and applications beyond organizations' boundaries. And when this happens, they also know that data is getting shared extensively, both internally and externally. And they do not, again, get visibility to how critical information is flowing within the organization and sometimes external to the organization, and what sort of controls have to they have in place to protect it. Because despite having prevention controls like DLP, CASB, next-gen firewalls, rights management, since they don't have context to this information, it becomes a big challenge for them to configure these tools to protect critical information because they do not know what that critical information is. Next slide, please, sir. So let's now see how organizations should approach this, or rather, how could identity to information solve these challenges that we just discussed a while ago. There are a lot of data, we already talked about it. There is a lot of data and organizations do not know what that is. So what identity or data identity establishes for organization is translating this data into meaningful information. So how could organizations convert this data into meaningful information? By going and categorizing them, classifying them, and adding enough context about it. So instead of just seeing that it as data, whether it's regulatory data, whether it's finance restricted data, whether it's intellectual property within the organization. So organizations get this visibility by embedding identity to information. Once they embed identity to information and get this knowledge about information, then whatever is key information that they want to analyze, they just can go and look for information of interest to them, understand who's accessing it, what is that information, what data stores are residing that, what data stores are typically having this information, how and when this information is getting accessed. So once organizations get this visibility, then they can translate this visibility into intelligence, which can be, or rather I would say actionable intelligence. So now let's take, for example, regulatory data. So where is this data stored? I mean, this regulatory information getting stored beyond organizations' geographical boundaries. Are users sharing this information without encrypting it, which again is a privacy violation? Or if it's intellectual property, is it being stored on a public storage site? So organizations then start getting enough intelligence about information of interest for them, and then they can come up with meaningful actions to prevent risks because of that information being shared. So like say, for instance, if it's regulatory information, they can just come up with controls that this information is authorized to be stored only in these data stores. If it's finance restricted information, it can't be viewed by anybody other than finance users within the organization. So we strongly believe that identity to information is going to help organizations translate data into meaningful information, and they can get enough intelligence about that information and convert that into actions so that they protect information significantly with investment that they've already made around data protection or data management. Next slide, please. Let's take an example. How technology can help organizations to identify this information easily or automate data identification comprehensively. So let's take this document. It's a mortgage loan agreement draft, which is critical, and it's got a lot of valuable information there. So the critical parameters that when organizations look at technology or enforcing automation for identifying information, the critical parameters that they need to look at is document properties. I mean, who's created the data, where is it residing, what is the file type, and then accordingly determine how it needs to be categorized or classified. Document structure. I mean, if it's a meeting minutes template, if it's an RFP document, if it's a proposal template, how exactly, is there a way for us to learn critical information templates that exist within the organization? How can they leverage technology to learn these templates? Organizations can also leverage machine learning. I'll explain that in the next slide, how they can leverage machine learning to look at document structures, keywords, using regular expressions, identifying personal data. So all these are some of the parameters that they need to look at when they are looking for technologies to identifying information automatically. And once this analysis is done, information then can be categorized and classified. There are a few technologies which only will classify. I mean, they probably will classify this document as restricted or confidential. But what additional insight that you can gather from that particular information? Categorization is important. Is it confidential? Is it customer confidential information? Is it finance information? Is it intellectual property? Is it regulatory data? So all that additional insight has to be provided other than classifying that information. Next slide, please. So look at, this is how organizations can leverage the technology. So this particular slide highlights few sections that the tool is analyzing. So mortgage loan is a keyword that's being analyzed. And then the tool is also analyzing a lot of PII attributes, the name, the address. You could also see social security numbers and phone number. If you can just look into that slide deeply, you could understand that the format looks the same. The social security number and the phone number looks the same. So how can the technology help organizations to distinguish between social security number and a phone number? I mean, organizations can leverage machine learning, deep learning, or natural language processing for that. And the last section at the bottom of the document, it's also highlighted because that is learned through machine learning. So once the tool analyzes all this, next slide, please. This can be translated into intelligence. So all the analysis that's done by the tool can be captured into metadata, and that could be persistently embedded into document properties. Just look at that tabular column on the left-hand side for you to get more insights about the intelligence that we embed into the document. First, of course, we categorize, the technology can categorize this document to be a loan agreement because that is done through machine learning. In this specific case, we have, since the customer was interested on whether this, they wanted to flag any document which has got GDPR information through metadata. So we are flagging that it's got GDPR metadata. And we can also highlight what PII attributes are there in the document. You can see name, address, location, date of birth, all that is there. And if there is if organizations want to enforce a retention date to limit liability, especially if it has personal identifiable information, they can put a retention date. In this case, like the way you could see, we have put a retention date that after this date, the document should be deleted. And you see something called loan ID there. So in this specific case, the customer wanted to extract anything under agency case number, which is the loan ID number, into the metadata, so that for forensic reasons later on, or for when they want to perform a discovery, how many documents do they store with this loan ID? Or what all PI attributes are they storing for this loan ID? So then it becomes easy for them to go and perform analysis. So technology can significantly help in analyzing content in documents and emails, or a lot of unstructured data that exists within an organization, and create a lot of intelligence based on analysis and make this intelligence persistently available within the document. So once this intelligence is embedded into the document, next slide, please. You could see that this intelligence can be translated into meaningful actions. Like the way I mentioned earlier, this is a restricted information or confidential information. So the DLP investment that you have done can just look at this metadata and ensure that this data doesn't go to wrong hands. If it is regulatory data, for instance, and if it has to be encrypted, then if you have invested on IRM tools or encryption tools, those tools can just read this data and ensure that whenever there is GDPR information or personal identifiable information, that information gets encrypted. Pavan talked about data sovereignty. Certain personal identifiable information has to be there within specific geographical boundaries. So since it's got European Union PII, so you could see there in that Excel sheet, the data center source is EMEA Zone 4. So your archival tools, your backup tools can just go and look at this metadata attribute and understand that this information should be only backed up on this particular data center. A mirror copy can't go to any other data center outside this zone. So every investment that you have done already around data protection or data management, you can maximize investment out of it by leveraging identity and the intelligence that an automation tools can provide by adding a lot of intelligence into documents and emails. Next slide, please. So I just forgot to mention, I'm sure you should be having a lot of questions before I move on, not just from my presentation, but also from Harsh's and Pavan's presentation. If you have any questions, you could see there is a chat window. Please feel free to go and type your questions there, so that once we finish the sessions, we'll be able to address all your questions later on. So now you could see that data identification has become the orchestration layer. Like the way I said, it gives a lot of intelligence to unstructured data. And once that foundational aspect of data identity is established, every other control can be automated. So DLP, you can straight away state that no restricted or internal information can be sent externally. Like the way I said, information rights management, you can automate information rights management. Organizations who have invested on IRM tools struggle to automate because it's manually driven. Users have to go and manually enforce rights. But that gets automated because of data identity. If organizations are using cloud applications significantly, one of the biggest challenges that they have is to understand what data is getting uploaded and what data is getting downloaded from these cloud data stores. So once identity is established through CASB, organizations can then decide these specific information can't be shared to these cloud data stores, or restricted or internal information cannot be downloaded to unmanaged assets. Finance restricted information cannot be shared with any user other than finance department. So every control, like the way I just mentioned, get a lot of value because of data identity, and organizations can orchestrate and automate security based on identity. Next slide, please. So I'll just go through this. I'll just try to explain this with an example. There'll be some animations here, Nagesh. So just I'll just say click. Yeah. So in this case, Bob is a financial analyst who's working for a bank, and he's working on some compensation data which he has to share with senior executives and get their approval. So it's after an appraisal. He's working on the revised compensation plan for all their employees. So he has to share this with the executive to get it approved. So again, we are all working from home now during odd hours. So he started this work maybe with a beer in his hand, working on it. He ensured the information is created properly. He completes the work at 2:07 and then sends an email out. And before he sleeps, he just gets a feeling that probably he sent this attachment to a wrong person. And he knows that since he's from HR, what legal implications it could bring because it's got a lot of PII information there. So instead of sending it to Mark, who is the CFO, he sent to somebody else who's a contractor. So let's see, how intelligent data identification would have prevented this mistake. So ideally, if this had happened, if organization has got a DLP in place, an incident is already created. We are not preventing an incident is already created. And once an incident is created, especially since this deals with regulatory information, it has to be reported. Organizations also need to understand how should they go and remediate, respond, and manage this particular incident. But now let's see how intelligent data identification could have prevented this incident. Next slide, please. So first thing is automated categorization. Like the way I said, there are technologies available where organizations can feed critical information types. I mean, if there is a compensation plan template, if it's a proposal template, if it's a bid template, they can go and feed that to the machine learning engine. Sorry, just please wait, Nagesh. When I say next click, you just do that. Go back to the earlier one, please. Yeah. So now, when the user is creating a file, in this case, a compensation plan, or working on that particular file, next click, please. And when he saves it, just click, Nagesh. The tool then analyzes through machine learning whether it's matching the training, whether matching the data that it's already learned. And in this case, since it's already learned the compensation plan, it then understands it to be HR data. Next slide, just click, please, Nagesh. So then the file gets categorized automatically as HR document, and we are obtaining user consent. I mean, there could be two options. Either the file could be automatically classified as confidential and category could be HR document, or we could interact with the user and get his consent that yes, it's a HR document and it should be classified as confidential. Next click, please. Yeah, or like the way I said, optionally, the file could be automatically categorized and classified. So once this is done, next click, please, Nagesh, or next slide. So when Bob was clicking send on his email, the tool automatically would have prompted him that he's sending critical HR category information to an external recipient. Then he would have realized, oh, it's a different Mark. It's not his CFO. So with data identification, what essentially happens is an incident is prevented closer to its source. User is made more aware that, and once that is done, an incident is not even created. Then the organization doesn't have to go through managing, remediating, and responding to incidents, especially if it's regulatory information. So that's the biggest benefit that we believe data identification tools can bring for organizations, because identity is established to document with user consent, and an incident is prevented from happening. Next click, please. And it's just not through machine learning. There are various other ways with which we can also look at regulatory information or critical information. It could be through something called smart regular expressions, with which we can detect PII. Next click, please. It could be not just HR document. We can also learn balance sheets, press releases, contractual information, and there are some information types which has time sensitivity, and organizations struggle to protect that information. Like, say, for instance, financial statement. A financial statement before the quarterly results are announced, it's a restricted information. But once the results are announced, it's public information. So how do you put a timestamp to determine sensitivity? So data identification tools can also do that. So like the way I said, categories of information can be derived effectively for different unstructured data that exist within various business functions by leveraging various identification techniques. Next click, please. And if it's personal data, then it's critical to also leverage natural language processing or deep learning, because it's not easy to identify personal information. So Indian names, for instance, or how do you differentiate between a social security number or and a phone number, like the way I just mentioned earlier. So organizations can leverage natural language processing without coming up with complex regular expressions to go and detect these data effectively. Next slide, please. So we talked about data at creation. Now, the example earlier talked about data at creation or data in motion. The user was creating a document. How could organizations leverage technology to automate identification? But now let's talk about data at rest. It's not just about data that the user is creating. There could be a lot of data that is already created and residing in different data stores. So let me take an example. A file server, for instance. Let's take a file server with 100,000 files, and organizations do not have visibility what files exist in those file servers. Next click, please. So there are technologies which can perform discovery. Yeah. Did you click it? Yeah, finish the animation. Yeah. There are technologies, which can go and perform discovery, like the way in this example, it can go and perform discovery on files in file server and help organizations get visibility like that. Okay, there are, in those 100,000 files, probably 20% of files have got sensitive personal data. Another 40% has got organization sensitive information or intellectual property. And we also have seen a lot of legacy data. What do you want to do about it? I mean, what we mean by legacy data is data that is created maybe 3 years or older and it's not being accessed at all. And from users' endpoints, we also have seen a lot of videos and JPEGs. This could be probably, it's consuming a lot of storage, and it could be probably personal data. So once organizations get this visibility through the same tool, the discovery tool itself, then they can decide what sort of actions that they need to enforce for these data types. If it is with PII, they can decide, okay, classify it as restricted, categorize it as regulatory data, and I want to ensure it's also encrypted. So we turn on those flags. So if organizations have already invested on IRM tools, it can go and enforce rights or enforce encryption. If it is organization sensitive data or intellectual property, it can classify and categorize accordingly. And what we also can do is, if there are specific data types residing on an open file share, like say intellectual property, it should be ideally in an engineering folder or manufacturing folder, but it's there on a finance folder. So the tool can also automatically understand that and quarantine that file to appropriate data folders, like move intellectual property from an open file share to only manufacturing or engineering folder. The tool can automatically do that. And if it's legacy data, if you don't want to store this in a high cost storage device or in cloud, you can move this legacy data to a low cost storage device through archival and enforce retention. So beyond, say, in 3 months' time, this data has to be deleted. And the same thing for videos and JPEGs. So it's not about data creation or new data that is being accessed by users. It's also about data that is already created. Organizations can leverage technology to and leverage automation to understand what the data is. And once they get that visibility and insight, then they can determine how it needs to be protected, and they can take actions accordingly. Next slide, please, Nagesh. Okay, so now let's see how this has to be approached in actual deployment. I mean, organizations, you might be having a lot of questions. Can every information be automatically detected? How do I approach this? How do I leverage technology? How do I ensure I classify all information by getting user consent? Definitely, it's not possible for automating detection of data for all information types. So the analogy that I typically give when it comes to identifying information is spell check. So every user, as part of the culture, we do spell checks before we save a file or send an email, because we don't want to create information with errors or mistakes in it. The same way, the same culture has to be established when it comes to identifying data. In order to avoid users from creating mistakes or data breaches unintentionally, they have to identify information. Once they identify, organizations can enforce action. So why is that the user is okay to do a spell check before they save a file or send an email? Because it's very easy. The number of mouse clicks that he has to do is going to be very minimal. Most spell checks are automatically corrected. Errors are automatically corrected. There is suggestion given to the user. The user has to choose one from the suggested option. And for very, very few, it's going to be user driven. I mean, everything can't be automatically corrected or suggested through a spell check tool. That's exactly how data identification techniques needs to be approached too. Most data, I mean, like 40 to 50% of data typically can be automatically identified. Another 20 to 30% of data can be identified through suggestions by interacting with users and getting their consent. And the balance has to be manually done. And the best part about data identification as a technology is it will not allow a user to save a file or send an email without establishing identity. Irrespective of how it's done, it can be automated or through suggestion, or it could be manual. But the tool will ensure that without establishing identity to the information, he cannot save a file or send an email. Next slide, please. So let's take an organization scenario. I mean, what I essentially mean by culture is people or process. The most critical thing that organizations needs to assess is what is their current data security culture around data security. How are the users aware? Are the users aware about critical information that they're handling? What sort of awareness campaigns? So based on the awareness levels and culture that exist, organizations need to evaluate what sort of awareness and communication plan that they need to derive, and technology can help significantly there. And then once they do this assessment is when they have to look at the technology. Next slide, please. What essentially we have seen is, especially when it comes to data protection, organizations look at technology more from a feature functionality perspective. Whether the technology can enforce classification, what all automation options are available within the technology, without missing or without analyzing what culture exists within the organization. Yes, the tool can offer a lot of capabilities, but is the organization ready to embrace it? Or how are you going to make the organization embrace those different capabilities available within the technology? How could the technology be tailor-made to fit into the organization culture? These aspects typically miss when organizations evaluate technology. Let's take data identification, for instance. Organizations see what all labels can the classification tool provide. How easy it is for the end user to go and classify information without realizing just classification. Are they going to get enough insight about it? Even what if the technology is just classifying files into 4 different buckets: restricted, confidential, internal, and public? What is that they're going to do with that? How are they going to understand whether this is a finance-related information, whether it's intellectual property, whether it's regulatory data, what regulatory data is available within the document? So those things are typically missed when it comes to leveraging technology. And based on the information sensitivity, the cultural aspects and the technology needs to be fine-tuned. I mean, let's say, for instance, if it is regulatory information, like Pavan mentioned, we have to establish a culture where people know that they are dealing with regulatory information, and these would be the implications if they create a data security breach. So that culture has to be established. Those awareness have to be in place. They can leverage technology now to automate. So they can't just leave the user to decide whether it's personal data. So they should leverage technology and automate controls. Automate identification of personal data, and ensure that through technology they also establish awareness. Because right now, analysts actually say that 1% of organizations' IT budgets goes on awareness campaigns. So whatever investment the organizations has done in coming up with those wallpapers on endpoints or pasting banners in organization floors, all this is not going to happen. And users are working in a stressful environment now from home, and they're not used to it. So how can they leverage technology to create active awareness campaigns? So all that needs to be considered before approaching data identification. So next slide. So where do organizations start? So like the way I said, we typically recommend organizations to take this approach. The one on the bottom is how should organizations decide when to automate identification of information. And one on the left side talks about the level of sensitivity, high risk to low risk, and security culture. When I say top down, it needs to be pushed from top, ideally the senior executives, and bottom up is business contributing to the security culture. And so it varies for different information types. Like the way I said, based on sensitivity, if it's regulatory information, it has to be top down. Organization needs to establish culture where users are aware that they're dealing with regulatory information, and this will be the policy that will be enforced for violations. And technology typically has to be automated. So automation should be high for high risk information, because you just can't depend on a user to go and identify that particular information. But it could be different for an employee's own personal data. It could be his own payslip. It could be his own bank statement. It could be his own credit card statement. So then we have to interact with user and leverage technology to interact with user and make him to decide whether it's personal data. I mean, if you see one credit card number, if you see, say, one payslip, if you are just seeing one bank account, then there are chances that it could be employee's own personal data. So then allow the technology to interact with the user and check whether it's his own data, and then capture that into the information and provide that additional intelligence. So even when we do deployments as consultants, we categorize information into different buckets. We understand what is the security culture that exists within the organization and how it needs to be fine-tuned based on the sensitivity of information. And once this is done, then I think organizations can categorize protection of data based on sensitivity and maximize value out of it. Just next slide, please, Nagesh. I'll just give a quick overview. I think I just have a couple of minutes more. Just a quick overview on Titus. Titus is headquartered in Ottawa, Canada. It's a 15-year-old company. We are the pioneers when it comes to helping organizations identify data. So we are privileged to show some of the brands that we are working with globally. And the one on the top side is customers in India. The reason why we wanted to show this is, I'm sure you would agree, data identification is not an easy strategy to embrace. Because unlike any other technology, it interfaces with the end user's day-to-day work life. Like the way I said, user will not be able to save a file without establishing identity. User will not be able to send an email without establishing identity. So it's going to interface with the end user's day-to-day work life. So since the product is there for 15 years and we have experience in deploying classification and identification as a strategy for all these customers globally, the product has evolved. And we also understand what are the different use cases that these different industry verticals have. And we could help organizations to focus on the low-hanging fruits and establish data identification as an orchestration layer to mitigate data loss risk significantly. So in India, we established operations in March 2018. So we have a full-fledged team with not just sales and marketing, but also a tech support, customer success, and professional services teams operating out of India. Next slide, please. So we talked about the challenges that the organizations have in managing volumes. I mean, a lot of unstructured data. We solve that problem easily by establishing identity and enforcing identity automatically mostly. So once it's done, organizations get the essential visibility. They understand where these information is getting stored, how is it getting shared internally or externally, and they can come up with an orchestration. They can use this identity as an orchestration layer to automate data security controls that they have already invested. So we have had instances where after, even in India, within the first 2 weeks, 40% incidents in DLP moving to block mode. Prior to that, it was in monitoring mode. We had instances where organizations saved 30% cost on storage after enforcing identity because they decided only restricted confidential and internal information should be backed up securely with 7-year retention. Legacy, personal, and public data would be backed up on a low-cost storage device with 1-year retention. So all these, I mean, identity becomes an orchestration layer, and organizations can optimize investment significantly. So next slide, please. So with that, I would just like to, thank the audience. Like the way I said earlier, if you have questions, please type that in the chat window. And my closing thought is, data protection is going to be very, very important. I mean, everything is around data right now. So it's important for organizations to identify data effectively. And once that is done, I think organizations can deal with different information types appropriately and secure them effectively. With that, thanks a lot. And over to you, Nagesh. If there are any questions, please.
Thanks, Mahesh. Thanks, Dr. Duggal. There are a lot of questions. I'm sorry, is somebody asking any question here?
You didn't cheat. You helped us catch him.
Yeah.
You like to help me count the items bought?
No, later after I'm taken shower. Chalo.
Nagesh, can you put everybody on mute, please?
Yeah, please mute everyone, Nagesh. Yeah.
3. 1, 2, 3. That's perfect.
Oh, that's an interesting. That's an interesting.
As far as classification is concerned, this depends on how we have created
Good
percentages.
counting.
Nagesh, I think what we can do is let's not use the audio for asking questions. Let's mute everybody, and if they have any questions, let them type on the chat. I request to all the audience, please don't unmute yourself. If you have any questions, please type it in the chat window so that there won't be any disturbance for others.
Okay, Nagesh, there are some questions on the chat window. Can you take them one by one, please?
Yes, sir. Just give me 1 minute. I'm just reviewing through. Okay, so I believe this question is for Dr. Duggal. What will be the challenge for companies while doing their privacy assessment once he proposed data protection bill 2019 come into play?
Thanks. Once this data protection bill comes into play, it will be a good idea for all companies to look at quickly doing a gap analysis. Because a lot of companies have already done various elements of protecting data. Some of them have installed solutions like what Mahesh was talking, the solutions that Titus is offering. So there's no point of reinventing the wheel. So when you look at your privacy reviews or your gap analysis, that can help us identify where are the gaps. And then we should only focus on fulfilling those gaps. Because it's pretty early right now. we don't know which is going to be the final manifestation of the bill it's going to come up. Because when I look at the way how Justice Sri Krishna Committee report came across, and then their personal data protection bill which was proposed, and the one that finally got tabled in Parliament was a completely watered down bill version of what Justice Sri Krishna Committee had actually given. So my practical experience, even 20 years back when the Information Technology Act 2000 was being done, was that let's not count our chickens before they hatch. Let's wait on for what is the final version of the revised amended bill that gets tabled back in Parliament after the Joint Parliamentary Committee comes up with its report. Yes, the current bill could start us in terms of ensuring that let's broadly take this current bill in its current form as a starting point, and then see vis-a-vis the key highlights, how much time, how much compliances have we done, or how much privacy reviews have we already done. Otherwise, wait on for the final law. And even when the law comes up, I believe they're going to give us some point of time for potentially complying with the same. Although there are two approaches. One approach in the government is, look, I notify, I pass the law, I publish it in the Gazette, and that's the law of the land. Thereafter, the clock starts for you, whether you comply or you don't comply or how you comply. In certain other cases, we also find that there is a window that's invariably given. Even under the Information Technology Act 20 years back, they had actually passed it in May 2000, but they actually notified it in October, giving people about 4-month window time frame for them to ensure compliances. I expect similar things to take place, but then please do your gap analysis rather than reinventing the wheel, because what ultimately would be relevant would be that once this law comes up and our documented processes are on the same wavelength, the same platform. In case if you think you want to make some manifestations, or shall I say customizations, you could still do that. But so long as you substantially comply with the law, that will be okay, fine. Otherwise, the problem is some of the fines that they are proposing. When I look at the personal data protection bill as it's been passed in or presented in Parliament, it's tremendously inspired by the GDPR. We're roughly on similar lines. We're also talking about a 15 crore fine, which is about 4% of the global turnover for an average company. So there is going to be also a data protection authority that's going to be established. That data protection authority will take time to come up with rules and regulations. So I believe we'll have ample time, but doing advanced preparation will always be helpful for us as corporates. I hope that clarifies. Thanks.
Dr. Duggal, there is a follow-up question. I think you have answered most of it for this question as well. So Mr. Srikanth asks, is it similar to GDPR when data pertaining to Indian citizens are processed outside India?
It's primarily similar to GDPR. In fact, one of the key problems of this law is that we have too much been inspired by GDPR. So with the result, you have more often than not doing a cut and paste of GDPR and putting it in India without realizing that you will need to customize it and localize it to make it workable in Indian conditions. But having said that, that 4% global turnover, that principle has been retained here, except instead of open-ended, they're looking at about fines of 5 crores, 10 crores, and 15 crores, depending on the various slots of situations that you fall in. The only new thing that's coming up is data localization. Here also, the governmental stand is, I feel, getting repeatedly watered down. And I think the government will have to look at the impact of this data protection law on cybersecurity. Because with cybersecurity breaches increasing so much, and given the fact that India does not have a dedicated law on cybersecurity, and further given the basic factum that the Information Technology Act 2000 is not completely covering all aspects pertaining to cybersecurity, I believe the government will have to do some marriage of convenience between data protection and also cybersecurity in the coming times. Thanks.
All right. So most of the other questions which were for Maheshwaran, I believe they have already been answered. Now the forum is open for people to ask questions. They can unmute one by one and they can ask questions to all the three panelists.
Nagesh, I think one of the questions which I felt was unanswered was, Mahesh, I think I would request you to answer, is whether an AutoCAD drawing be tagged
Yes. So we can classify any file, including like a diagram file or a CAT file or a text file. So any file, even if it doesn't support metadata, when it's there on the endpoint, we'll be able to establish identity and enforce classification there.
And whosoever asked this question is very, very relevant. Yesterday we were discussing in another forum that because of this COVID thing, we are deviating away from the physical and becoming more virtual. Some of the manufacturing designs will not be shipped as parts, but actually will be shipped 3D designs because of this a huge issue in terms of moving material from one place to the other place. So very relevant question.
Yeah, absolutely. And I think there was also another question on will the user be able to wrongly classify? And that's where and I think I want to emphasize on automation, right? So since we are going to analyze content and other attributes around the file, even if a user tries to change classification or wrongly classify, the tool is going to intelligently classify it accurately. And we also can ensure that once the information is classified, like say, for instance, the finance head is classifying a specific information to be restricted, finance restricted. If any other finance user is trying to downgrade the classification, that is restricted too. I mean, we don't allow, we can enforce controls like once a file is classified, only certain users have privileges to change classification. So all those things can be done through policies.
Is there any more questions, please?
And I think I see another question. Can we track the documents like who has opened and edited? So yes, once identity is established, we are not a file activity monitoring solution. Like once classification is or identification is embedded onto a document, once it's being opened through events, we can tell that these are the people who are opening it. And through discovery, we also can tell that these are the locations where the file is. But again, the use case is more of tracking activity to files, which is not the use case that we address. However, you can leverage our technology to also understand how restricted files are being accessed and where is it residing.
Mahesh, I guess there is one more question for you. What if user selects a wrong classification?
Yeah, I think I answered that, Nagesh. Yes. So users, even if they by mistake wrongly classify a document, the content, we are going to do content analysis intelligently. And that's how we automate classification and correct the wrong classification done by users. So we'll automatically change the classification back to the original classification based on the analysis that we do.
All right. Folks, any more questions? You can unmute yourself and ask as well.
So I think, Nags, it's perhaps, okay. Yeah, I think there's one more.
Yes. So again, if the tool classifies wrongly, if the automation, that's how we interact. So it's completely configurable. Like the way I said, when to decide automation and how to leverage automation and when to interact with user, all depends on the information type and the policies that we derive based on the requirements stated by business. So if we see that the tool is not accurately classifying or identifying information, we can also interact with the user, understand how it needs to be classified, factor that take that into consideration and accordingly classify too. So all those combinations are possible, and that has to be done based on the sensitivity of information and the criticality of the information. And also, it's not that we are going to before rollout. Ideally, we do a comprehensive user acceptance testing. We do all the testing to ensure that the tool is identifying information accurately. After which is when it's going to be rolled out to all users. So there will be comprehensive pilot testing before it's widely deployed. There's a question for maybe Pavan. I think.
What will be the minimum personal data numbers should be required to protect as per the data protection law?
Well, it's not a question of numbers at all. The moment you have one data set, you are covered. unless until it's your argument that I'm not dealing with sensitive personal data at all. In fact, the Personal Data Protection Bill as it's currently standing is only going to deal with two kinds of information. One is personal information and one is sensitive personal data. So in case as an entity, you're not covering any of them, then you can say, I don't really need to be bothered about the data protection bill. But if you're a normal company, you have got your normal employees, the moment you are having the payroll data on your systems, the moment you have the bank record data of your employees, the moment you have the medical data for medical leaves and encashments of your employees, you are instantaneously dealing with sensitive personal data. And that being so, every company that's providing a connectivity to its employees or that's just using the employees' data on its computer systems, the networks, would stand covered under the data protection bill. So I think it's a very, very broad coverage. It's not just going to be a normal company. I'm even saying my local Kirana shop wala, who only has about 4 people, but has those 4 people's bank account details on his system. He also would be required to comply with the local data protection law. But this is, as of now, it's currently happening. It'll be, my reading, it's going to be very, very hard for people to say, I don't have sensitive personal data. I don't have personal data. Now, when I say personal data can even be my name, can be my phone number, can be my email address, can be my home address, can be my home phone number. So if you're having any of those choices on your systems, you have to be mentally prepared. So by and large, I think almost 99% of corporates in India will be required to comply with the data protection law as and when it comes up.
And to add to what just Mr. Pavan mentioned, again, I mean, it all boils down to the risk posture that you have based on the number of personal data that exist in the particular endpoint or the information that you're sharing or in the particular email. So if there is also context provided to understand what volumes of personal data is going and what combinations of personal data is going, then accordingly organizations can also derive what controls need to be in place. Like say, for instance, if it's 1 or if it's less than 3, you want to treat that information separately, I mean, in a different way. But if it's more than 10, it's a high risk information that definitely you have to enforce stringent controls around it. So that intelligence also has to be embedded when it comes to looking at protecting personal data.
Okay, there is one more question, which is there any privacy rule or role in handling personal data? Is it?
Sorry, what's the question? Come back again, Nagesh.
Is there any privacy rule and role in handling personal data?
As of now, yes. You already have the provisions under the Information Technology Act and the IT Rules 2011. So, for example, if you are dealing with personal data, you are required to put in place reasonable security practices and procedures. For example, the law says that you must have an ISO 27001, which is one manifestation of reasonable security practices and procedures. Further, if you're dealing with the handling or processing of sensitive personal data, then you have to do far more compliances. For example, I not only need to have my terms and conditions in place, my privacy policies, my disclaimers, but more significantly, I need to get consent prior in point of time before I'm collecting such information. I'll have to tell the person concerned why I'm collecting this information, what is the objective, and how the information is sought to be either processed, dealt with, or retained at subsequent points of time, and who all will be able to have access, and for what particular purposes can the said information be used in the coming times. So all those consent requirements are very, very crucial. They're already embodied under the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data Information Rules 2011. Please ensure compliance with that. The problem is we are living in a litigious society. I cannot predict when the next time you're going to be hit by litigation. And when I look at the global landscape figures and the trends emerging, one thing is coming very, very clearly as a writing on the wall, that almost every corporate stakeholder will have to tighten their belts for potential legal exposure, litigation or proceedings of any kinds against them. They could themselves be litigating or they could be litigated against. So in this entire context, your electronic evidence will have to be of crucial significance. Don't think that, look, I'm working from home. I have this evidence. Let me copy it and save it on my local computer, and that's evidence. Sorry. The Supreme Court has come up with very detailed rules and regulations on how the electronic evidence has to be preserved and then how it has to be produced in accordance with Section 65B of the Evidence Act and in normal courts of law during legal proceedings. So the next time now you or your companies are suddenly realizing that you have not been able to fulfill your contractual obligations under existing contracts because of COVID-19, please don't wait till the time COVID-19 period comes to an end. Start collating the relevant evidence which is going to help substantially buttress or support your claim in the proper manner as has been given under the IT Act and also the Evidence Act. Let's go with the basic presumption that I will be sued or that I may be required to sue. And right now, when I talk with you, there's not much clarity as to what will be the ambit of force majeure. A lot of companies are thinking, look, in almost all my contractual obligations, I have this force majeure clause. So I will go under that and say, look, COVID-19 is force majeure. Please, I could not have done because this was an act of God. So I'm not going to be responsible. Please, I will request companies not to be in a state of complacency. Why? Because this is not what the law is emerging. Yes, in some portions of China, they have begun to start recognizing coronavirus as an act of God. But in India, we are beginning to hear different voices. In recent, one of the petitions before the Bombay High Court, the Bombay High Court refused to pass orders and refused to bite the argument that COVID-19 or coronavirus was an act of God and hence force majeure. So different high courts are likely to take different kind of permutations and combinations in terms of their interpretations of what force majeure is going to be. Well, we'll have to wait. If Supreme Court comes up with something definitive, that could help us, all of us. But when I look at Oklahoma in the US, a number of states are already asking President Trump to declare at a national level that the COVID-19 or coronavirus is an act of God and hence will be covered under force majeure to help the oil and other industries. Nothing like that is currently happening in the country. So don't be in any state of complacency. Please collate the relevant evidence, keep it with you, be prepared that you're going to be hit or you will have to be hitting somebody below the belt, and therefore have the requisite ammunitions ready for supporting your offensive or defensive capabilities once COVID-19 comes to an end. Thanks.
Well, thank you, Dr. Duggal, for those key insights. Thanks, Mahesh, for all the information around classification that's been provided. I would now ask Harsh Marwa to give a thank you note.
Next, first of all, Nagesh, very thankful to you, man. You've worked relentlessly to make this session happen. And folks, truly appreciate for each one of you coming on the call. And we will continue with this 360-degree series. I would, on behalf of iValue team and also behalf of Titus team, would like to thank Pavan Duggal, because every time Pavan is there and his content and insight brings a very different perspective to this industry, which has been for so many years been overwhelmed only with technology. I think it's high time we realize that technology has to work seamlessly with the legal and the regulatory framework, which is perhaps as critical or more critical. We only talked about the Western world at times, but today I think India is going through the same situation. So thank you very much, Pavan, really for your exemplary talk and great insight. And also, thankful to Mahesh for your time. And thanks to all of you. And as iValue InfoSolutions, as a technology aggregator, we will keep coming back with these 360-degree insight, and do share your feedback with us. We appreciate, and thanks once again to all of you.
Thank you.
Thank you.
Thank you.
Yeah, thanks, everybody. Bye.